Hi, everyone, and welcome to another episode of Legal Things. Today, we're talking about what are the legal grounds for getting a divorce. There's really only one legally recognized ground for divorce in Singapore, and that's the irretrievable breakdown of marriage. The other terms that we commonly hear about when we're talking about getting a divorce, such as separation, desertion, unreasonable behavior, or even adultery, these are the facts that can be used to prove to the court and can be accepted by the court to determine that the marriage has broken down irretrievably. To be clear, even though you may hear of people getting a divorce due to irreconcilable differences, you should know that this is neither a requirement nor an acceptable grounds for proving the irretrievable breakdown of marriage in Singapore. Instead, you will have to prove that your marriage has irretrievably broken down based on at least one of the following four facts. Number one, adultery. Number two, unreasonable behavior. Number three, separation. Number four, desertion. In 2023, mutual agreement will also be recognized as a fact to prove the irretrievable breakdown of the marriage. Proving adultery means that you must not only prove that your spouse has committed adultery, but that you cannot tolerate continuing to live with him after the divorce. The main hurdle with proving adultery is in getting credible evidence, either by yourself or with the help of a private investigator, of the extramarital sexual relationship between your spouse and the third party, especially because your spouse is not likely to admit to the adultery at all. When it comes to proving the unreasonable behavior of your spouse, you must show that your spouse has behaved in such a way that you cannot reasonably be expected to live with him. Having said that, what constitutes unreasonable behavior can be quite subjective, and some examples include the following: physical or psychological abuse, neglecting the family and spousal or parental duties and responsibilities, such as by persistently working long hours, not spending time looking after you or the family, and not providing financial support, or alcohol or drug abuse, compulsive gambling habits, having an inappropriate extramarital physical or romantic relationship, or deprivation of physical intimacy. Desertion takes place when your spouse has deserted or abandoned you and the family for a continuous period of at least 2 years immediately before the filing of divorce. To prove this, you must show that you have been living separately and your spouse has the intention to desert and no intention to return to you. If you and your spouse have lived separately continuously for a period of 4 years, then your spouse's consent is not required before you can file for divorce, and you only need to prove that you have lived separately continuously for a period of the 4 years. However, if you and your spouse have lived separately continuously for a period of only 3 years, you must also then prove that your spouse consents to the divorce. And a deed of separation can sometimes be used to prove this. The separation and living apart must also be decided by choice and not out of necessity, such as the separation only taking place because one of you was posted overseas to work. If you and your spouse briefly reconcile during this period of living apart, the separation can still be considered continuous as long as the period of the reconciliation does not exceed 6 months. But the time spent living together will not count towards the required duration of separation. Following changes to the law that are expected to take place in 2023, you may be allowed to divorce by mutual agreement in the future, where you and your spouse mutually agree that the marriage has irretrievably broken down, and this is then recorded and documented in an agreement, which will cover the following things: your reasons for concluding that the marriage has irretrievably broken down, the efforts that you and your spouse have made to reconcile unsuccessfully, as well as the consideration that the couple have each given to the arrangements for their financial affairs and any children of the marriage post-divorce. However, the court will still have the power to decide not to dissolve the marriage if it believes that there is still a reasonable possibility of the couple reconciling. So, now you know. If you enjoyed listening to this and would like to hear more, subscribe wherever you like to listen to podcasts and follow me on TikTok and Instagram. And remember, it's not rocket science. It's just legal things.